quoted during 2 presidential impeachment trials, has testified before Congress and advises federal and state lawmakers. He regularly appears on TV, the major networks, the major U.S. networks, and the BBC. He's also a frequent guest on NPR and other syndicated radio programs. He's published commentaries in the New York Times, Wall Street Journal, Washington Post, and other publications. Since 2012, Josh has served as a professor at the South Texas College of Law in Houston. He's also an adjunct scholar with the Cato Institute. He's authored 3 books. His latest, An Introduction to Constitution Law, was a top 5 bestseller on Amazon. We just a little side note here, we use his book with Randy Barnett.
I didn't know that.
Yeah, so 100 Supreme Court cases you have to know, I think, or I'm sorry, I'm butchering the title, but in our work with teachers on improving their constitutional literacy, yours is a go-to book for us.
Thank you.
So, thank you for that. Written more than 6 law review articles and been cited nearly 1,000 times. So selected by Forbes magazine for the 30 under 30 in law and policy. President of the Harlan Institute, and founded Fantasy SCOTUS, the internet's premier Supreme Court fantasy league. So we look forward to hearing from Josh. After Josh, we will be hearing from Professor Richard Brufeau. And have I pronounced that correctly? This has been some debate this morning, Professor.
It's actually Brufeau. You don't have to give it a French pronunciation.
Okay, Brufeau. Thank you for helping me with that. So Professor Richard Brufeau he's the Joseph P. Chamberlain Professor of Legislation at Columbia Law School. Since joining the Columbia Law School faculty in 1983, Professor Brufeau has combined public and government service with teaching, research, and scholarship. He is the law school's authority on state and local government. The news media often turn to him for his expert insights into and analysis of issues central to democracy and the political process, such as campaign finance reform, government ethics, gerrymandering, and fair elections. He's also a leading thinker on the new preemption critique of states that are increasingly passing ideological laws that override local ordinances. Working with the local Solution Support Center, he educates city and other county government officials on how to respond to state preemption. Prodigious scholar, Brufeau has written more than 75 law review and journal articles, as well as books and monographs, including Dollars and Democracy, a Blueprint for Campaign Finance Reform, Cleaning Up Hazardous Waste, Is There a Better Way? And the 5th, 6th, 7th, and 8th editions of the casebook, State and Local Government. Before joining the Academy, Brufeau was a clerk for Judge Shirley M. Hustetler on the Ninth Circuit Court of Appeals, and an assistant counsel to New York Governor Hugh L. Carey, and an associate at Paul Weiss, Rifkind, Wharton, and Garrison. He's a reporter for the American Law Institute's project on principles of government ethics and vice chair of the Citizens Union of the City of New York. Our final speaker today will be Professor Lori Riverstone Newell. Dr. Riverstone Newell graduated with an MPA and doctorate in political science from the University of Tennessee, Knoxville, which is her hometown. She lives now, though, in Bloomington, Illinois, with her husband and daughter. Her teaching interests include subnational politics, particularly urban politics and intergovernmental relations, also public administration and environmental politics. Her primary research focus is on the interaction of government and the U.S. governments in the U.S. intergovernmental system, specifically the tools and strategies used by state and local governments to accomplish their goals and defend their interests in America's highly competitive political system. She's received a grant from the Robert Wood Johnson Foundation to study preemption. Her goal is to bring together advocates and researchers. She has published a book, Renegade City, published numerous articles, journal articles, and is working on a new book, which will be published next year, Built for the Middle Class. So with that, we direct your attention to the screen where we have Professor Josh Blackman.
Thank you so much. I am sorry that I couldn't be with you here today. A lot of things got going on back home. I'm not in my usual spot, so the lighting's a little bit off. I hope you'll forgive me for the different ambiance. So the topic today is state constitutions and federalism. And I'd like to talk about one of the earliest cases involving state constitutions and federalism and vaccine mandates, which is, of course, Jacobson versus Massachusetts. This case that seems to never leave us. I have a new article on Jacobson called The Irrepressible Myth of Jacobson versus Massachusetts, and it's forthcoming in the Buffalo Law Review. It should be out later this year. So I want to give you some background about the Jacobson case that may not be obvious in many different forms, and then I'd like to bring it to the present. So at the turn of the 20th century, states began to require people to be vaccinated against smallpox. And courts largely upheld those measures as exercises of the police power. One such state was actually Massachusetts. And in 1902, Massachusetts enacted a requirement involving the smallpox vaccine. Later that year, the city of Cambridge prosecuted a person. His name was Henning Jacobson for refusing to get vaccinated. Jacobson was a Lutheran minister, and he argued that the law violated both the state and the federal constitution, federal constitutions. Now, Massachusetts has one of the oldest constitutions in the United States, if not the oldest, I think. It was written in 1780 by John Adams. So it's a very long-standing document. It's been amended, of course, but it's a very rich document that's been around for a very long time. Now, Jacobson was a minister. He did not raise any religious freedom arguments. Keep in mind, at the time, there was no incorporation of the Free Exercise Clause, so that wasn't really a thing you could do. At the time, Jacobson was convicted, and after trial, he was ordered to pay a $5 fine, the maximum fine permissible by law. Now, I want to make one point clear. Massachusetts did not allow people to be forcibly vaccinated. In fact, an unvaccinated person who paid the fine of only $5 was free to spread the disease to his heart's content. To use inflation, $5 is about $150 today. So this is more or less a parking ticket fine, at least a parking ticket in New York where I find myself now. The Boston Globe had an article in 1902, and it discussed a prominent anti-vaxxer back then. There was one person who paid his fine and went about his business. The Massachusetts Supreme Judicial Court upheld Jacobson's conviction. It found that individual liberty could be restricted to promote the common welfare. On appeal, the U.S. Supreme Court agreed. Justice John Marshall Harlan wrote the majority opinion. So long as there was some reasonable fit between the measures adopted and the government's interest, the law was valid. Still, Jacobson identified several limitations on its holding that are often disregarded today. So I'd like to now dive a bit deeper into the case. Who was Jacobson? He was a minister, and of some he's a character, actually. He was a very charismatic figure in 19th century Cambridge. He had been vaccinated against smallpox in the past, and he had very adverse reactions. He had rashes, he had pain. It lasted for months. Keep in mind, the smallpox vaccine was basically a form of cowpox. It was a related disease they would give you. His son was also vaccinated, also had issues. So Jacobson refused to go along with the requirement. The Massachusetts law imposed a $5 fine on those who did not get vaccinated. And I want to just put this into context. I went through the entire Massachusetts health code at the time to see whether various violations and penalties. $5 was the smallest fine available for any sort of health code violation. I think this tells us that the government was not entirely sure about this requirement, and they deliberately picked a very low penalty to sort of test its validity. Now, there was a trial. Jacobson was not the only defendant. There were actually several trials who were upheld at the same time. For whatever reason, Jacobson became the lead plaintiff in appeal to the Supreme Court. I don't quite know why, but there were several people who simply refused to get there. Okay. Jacobson then appealed the case to the state court system. And to keep with the theme of our Constitution, he raised a number of assertions under the state Constitution. For example, Part 1, Article 1 of the Massachusetts Constitution, Article 4, Chapter 1, Part 2 of the Massachusetts Constitution. These are provisions that say the legislature can only enact wholesome and reasonable laws. And they argue that this law was not reasonable, kind of a substantive due process challenge. He raised a claim under Article 10, Part 1 of the Massachusetts Constitution, which gives every person the right to be protected in life, liberty, and property. He said the law violated Article 14, Part 1 of the Constitution, and that provision governs the right to be secure from reasonable searches and seizures. His most fascinating argument, though, is actually based on the takings clause. And just bear with me here for a minute. He argued that the vaccine was a taking of property. Huh? So here's what he argued. He said, well, if I get the vaccine and I get sick, I can't work. And if I can't work, I will lose my salary, my livelihood. And if I lose my salary, I won't have money. Is the government going to pay me back for my lost wages? Of course not. So he basically argued that by forcing him to get a vaccine which could make him sick, he was losing money and it was an uncompensated taking, which was, I mean, a very creative argument, just totally aside. But the OSHA mandate released this morning actually requires employers to give paid leave if a person's sick because of the vaccine and they have an adverse reaction. So even today, we're dealing with those issues. Okay, so anyway, so Jacobson was convicted. The trial court and the Superior Court rejected all of his arguments. And the case went up on appeal to the state Supreme Court. Now, this is actually fascinating. What happened after his conviction? Was he sort of ostracized or kicked out of society? No. In fact, he continued to appear in public events with basically everyone. He'd appear with the mayor and with the senators and everyone else. My favorite anecdote is that the city of Boston sent a delegation to the World's Fair in St. Louis. The best people in Boston, and he was actually sent out of state as a delegate to the World's Fair, even though he refused to be vaccinated. And I just find that story sort of hilarious because today people are sort of like ostracized and put in this sort of bubble if they're not allowed to, if they refuse to be vaccinated. All right. On appeal, the Massachusetts court affirms, and they pretty briskly reject all of the state court arguments. I'm sorry, all the state constitutional arguments. And again, this is the state court, and it's entirely within their prerogative to rule on the state constitutional claims that they wish. Perversely, they spent almost all their time on the federal constitutional claims under the Due Process Clause of the 14th Amendment. And the court more or less said that this is a reasonable measure. They said this was a valid public health measure. But the court did make a very strenuous point that it's not in the power of the state to forcibly vaccinate someone, that the most the state could do is just to penalize a person. There were some suggestions about whether you could keep a person incarcerated indefinitely until they got vaccinated. This is almost like the case of Buck v. Bell, right? If someone has some sort of health ailment, can you keep them in captivity, institutionalized, until that health condition no longer prevails? Several of the courts in this region suggested that there was some limit over what kind of punishment can be imposed. I hate to say proportionality, but that's sort of what it sounded like. If this is a vaccine, a nominal fine is okay. But there was one court, I think it was North Carolina, where the law said you can hold someone in jail for 30 days for not getting vaccinated, and they can hold them for another 30 days, another 30 days. So there were some courts that approved of this, but there were some dissenting voices at the time. All right. The case goes to Supreme Court, and as we all know, the Supreme Court didn't really care about the state common law claims. The U.S. Supreme Court ruled entirely on the Due Process Clause, and they said that there's no basis. All right. So where does this leave us? In the wake of Buck v. Bell, states were given very, very broad latitude to enact a wide range of public health measures on really just about any issue. The most prominent example is usually school vaccines. And indeed, school vaccines predated Jacobson. Even before Jacobson, schools were requiring smallpox vaccines. But Jacobson was extended to far more context beyond vaccine mandates. To involve, for example, quarantine laws. If someone came from abroad with cholera or smallpox or Ebola or pick your ailment, the states were allowed to detain these people indefinitely. But eventually, probably around the 1940s, 50s, and 60s, the Supreme Court began to animate the Free Exercise Clause and say the Free Exercise Clause limited the state's police power. So soon you would have religious objections to various health laws. And this is where Jacobson sort of gets a little fuzzy. Jacobson was decided as a substantive due process case long before the ratification of before the incorporation of the Free Exercise Clause. And it was never clear, to me at least, what the right relationship should have been between Free Exercise Clause and due process. The courts throughout the 20th century were sort of uneasy. They said, well, we have this case at Jacobson that says we use a rational basis standard for public health measures, but then we have these free exercise cases that say we apply something that's far more rigorous and rational basis. The court sort of dodged the issue, said, well, even if we apply heightened scrutiny, the state can still impose vaccine mandates. But that brings us to COVID. And during the COVID-19 pandemic, all this case law sort of just blew up. Things changed radically, almost overnight. And judges were suddenly tasked with deciding the validity of health measures that really had never been used before. I'm not just talking about, quarantine laws. Houses of worship were closed almost indefinitely in some states. Worshiping was limited to 10 people. If a synagogue of 1,000 or a church of 1,000, you could have 10 people in there. And without fail, judges reached to Jacobson. And I think they read far more into Jacobson than was actually there. And I think leading this charge was Chief Justice Roberts. Although I don't know if he actually intended this. Roberts decided a case called South Bay versus Pentecostal Church, which upheld California's restrictions on houses of worship. And I think that Roberts suggested that Jacobson is the appropriate framework for really any pandemic-related case, not just those involving vaccine mandates. This was a significant expansion of the rule of Jacobson's rule. I think Jacobson was the rule, so to speak, for much of the summer of 2020. But when we get to November of 2020 and we get to Roman Catholic Diocese of New York versus former Governor Cuomo, I like the former part. Governor Cuomo imposed very strict restrictions on houses of worship and religious schools. To be candid, I was one of the people who sued him over this, and I kind of won. I represented a Jewish school in Far Rockaway, Queens. But the court in the Roman Catholic Diocese case didn't follow Jacobson. And in fact, we have a concurring opinion by Justice Gorsuch saying Jacobson has no bearing on the pandemic. Now, that was not a majority opinion. It was just a concurrence. Of course, Roberts was also a concurrence, but it was a concurrence people liked. So in the wake of Roman Catholic Diocese, I think this Jacobson case, once again, is sort of on the outs, although judges still cite it, perhaps under circuit precedent. Right. So where does this leave us, right? What is to bring us back to the theme of our conference, the state constitutional power to guard against pandemics and disease? I think states have operated in very different functions. If you look at a state like Texas, where I live, not there at the moment, but where I usually live, the Texas governor has used his emergency powers to be anti-COVID preparatory measures, right? He's prohibited vaccine mandates. He's prohibited mask requirements in local municipalities, right? He's gone out of his way to use his state authority to eliminate local restrictions. I know my colleague is talking about state preemption of local laws. Texas is perhaps ground zero for that. The city I live of, Houston, has tried to impose various mandates that have all been preempted. School districts have tried to have mask mandates that have been preempted by the governor's order. In contrast, other states like California have gone the exact opposite direction. They've used their gubernatorial powers to impose very sweeping restrictions, even when local municipalities would not favor them, right? A local town with a very low population may not favor a mask mandate in their schools. But there's sort of been this one size fits all in the state. And now I guess it's perfect timing. Just this morning, the Biden administration announced its new OSHA rule, which will apply to, I think, almost 90 million workers in the workplace. Now they're subject to a mandate of a vaccine or testing requirement. So in many regards, the sorts of issues that Massachusetts confronted 115 years ago are not very new. These are old issues, and they seem to recur over and over again. I apologize in advance. I will need to leave early. So John, if it's okay with the moderator, maybe I can take some questions now. So I'm definitely here from people. Otherwise, I'll be happy to yield my time. And I really can't hear you up at the microphone, so you have to just speak up a little bit.
Josh, we're just telling everyone they need to speak into this roaming microphone so you
Oh.
can hear them.
Excellent. I like that, the roving microphones, kind of like this, brooding omnipresence in the room.
Thanks. Josh, I have a question. You referred to the OSHA mandate that came down today. What do you have any initial thoughts on? I haven't yet had a chance to read it. You probably haven't had a chance to read it, but maybe you've looked at it. Any what should we think about in terms of legal precedents as we lead into to the Biden administration's vaccine mandate for employers?
Right. So excellent question. The federal mandate that came out this morning is nearly 500 pages with all the various recitals and preambles. So I've not read it either. 500 pages is a very long document to read. The first thing to keep in mind is Jacobson, we've been talking about, is not directly relevant, right? Jacobson's the state police power case. This is a case under the federal government. The next constitutional issue we have to think about is delegated power. OSHA was enacted in the 1970s. It isn't entirely clear to me that the statute enacted in the 70s gives OSHA such broad, sweeping authority to regulate every aspect of employers nationwide. Another constitutional issue is, of course, religious freedom. This policy barely mentions the free exercise clause in RFRA, the Religious Freedom Restoration Act. Why? Because it says, really not our problem. You can either get vaccinated or go get tested and masked every week. I don't think that's going to cut it. So, for example, ministers and other people of the cloth will be subject to this rule, and they may have objections to having an onerous testing requirement or perhaps wearing a mask when they're not involved in their various religious services. I think there's also state problems, right? This law applies to state employees in many regards, and so there's preemption issues, right? And when we have talking about preemption, when the federal government preempts the state government, you have a very clear statement that this was intended, and I don't know that the OSHA law goes as far. What I will tell you is the litigation is going to be ugly. There are going to be lawsuits in every state, in every court, everywhere, like starting tomorrow, or maybe even today if they get up quickly enough. What actually happens is all the issues are consolidated into a single court through a lottery, which is kind of crazy. So one lucky circuit court of appeals will get all these cases, and we might get an injunction sometime this week or next. But I don't think Biden actually needs to win, and this is an important point. Even if he loses, right? Even if he loses, people have already been getting vaccinated in anticipation of the mandate. That was always the goal, right? 70%, 80%, whatever the goal is, even if he gets this policy enjoined and never goes into effect, he'll have already won. But thank you so much for the question.
So maybe this would have been better suited to hold on to, because I think some of the other presenters might have a perspective on this. But when we look at, we're here today sitting in Utah, which has enacted some anti-COVID policies as well.
Mm-hmm.
And as a result, we have higher case counts than some of the states bordering us. And you can see those trends with the topic of COVID, or yesterday we were talking about how some states are expanding rights and some states are restricting rights. And my question is that a consequence of federalism that we have to live with because we want to keep federalism around, or is that a success of federalism?
Really good question. So anti-COVID, is that pro-COVID? I've just, you got the double negative, right? You may not like my answer. I think it's a success of federalism. I don't think we should have a single 50-state solution on things. I think it's a value judgment over how states choose to respond to public health crises. What I'm about to say may sound jarring, but saving lives is not the only state interest, right? There are other interests they can pursue, and the state may choose other interests that may result in greater freedoms but more deaths. It's a jarring thought, and it perhaps seems callous, but it's true. States have policies on tobacco, on alcohol, on drunk driving, on countless areas where they accept greater risk to give people more latitude in their lives. So I don't think there's anything novel about it. Perhaps the COVID death counts are higher than others, but I think it's quite long. You know, when did states first begin to prohibit indoor smoking, right? When did states first begin to prohibit drunk driving? When did states, you know, have speed limits of 65, 55, 85 miles an hour, right? There are, I mean, I'm in New York City right now, Manhattan, everything's illegal here. You can't cross the street if you want. You know, there's signs telling you can't cross anything. I think federalism lets that happen. And if, you know, people don't like it, they can move. We've been in this for a year and a half. I think at this point, people should have a very good sense of how different states approach things. And some people say, oh my God, I don't want to live in Texas anymore. Okay, then, you know, move to New York. Or my God, I love how Texas is, and then move from New York. So it's a callous answer, but I do think it reflects the success of federalism.
Maybe one more question before we move on to Professor.
And I appreciate you guys being flexible. I'm hectic week. I'm in and out of places. If you see the red bracelet, you know what's up. Okay.
Okay. All right.
Thank you all so much.
Thank you, Professor Blackman.
Thank you.
Thank you. Yep. And best of luck where you are.
Thank you so much. And I'll be listening, but I'll turn my camera off.
Okay, great. Okay, and with that, first